Today's topic is right to constitutional remedies. Article 32 to 35 and Article 359 deals with the right to constitutional remedies. So let's get started. Part 3 of the Constitution provides for legal remedies for the protection of these rights against their violation by the state or other institutions or individuals. It entitles the citizens of India to move the Supreme Court or High Courts for the enforcement of these rights. The state is forbidden from making any law that may be in conflict with the fundamental rights. Ubi rebe remedium, which means there is no right without legal remedy. Fundamental rights would be useless unless there are adequate provisions to enforce them. As observed by Supreme Court in Fertilizer Corporation Kamgar Union vs Union of India, a right without legal conundrum of a most grotesque kind. Accordingly, the right to enforce all the fundamental rights is itself made a fundamental right under the Constitution. Article 32 can be summarized as follows. The Constitution guarantees the right to move the Supreme Court for the enforcement of the fundamental rights. This is in Article 31 of 1. The SC has the power to issue directions/orders/writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate, for the enforcement of any of the fundamental rights discussed above. Article 32 of 2. The powers mentioned in Article 32(2) above can be exercised by any other court empowered by Parliament. This is Article 32 of 3. When Article 32 was being drafted in the Constituent Assembly, Dr. Ambedkar, the father of the Constitution, was heard to say, "If I was asked to name one particular article in this Constitution as the most important, an article without which the Constitution would be a nullity, I could not refer to any other article except this one." Thus, Article 32 enshrines a very valuable right. As observed by the Supreme Court, if a prisoner's fundamental right is flouted or legislative protection is ignored, the Supreme Court's writ will run, breaking through stone walls and iron bars, to right the wrong and restore the rule of law. As in the case of Chalas Shobraj vs Supted, Central Jail, AIR 1978 SC 1514.
So, what is a writ? Writ's a written order issued by the Supreme Court of India to provide constitutional remedies in order to protect the fundamental rights of citizens from a violation. Now let's see what is a writ petition. A writ petition is essentially a court petition for extraordinary review, asking a court to intervene in a lower court's decision. Under the Indian legal system, jurisdiction to issue prerogative writs is given to the Supreme Court, and to the High Courts of Judicature of all Indian states. Parts of the law relating to writs are set forth in the Constitution of India.
Type of writs. The Constitution empowers the Supreme Court and High Courts to issue orders or writs. The types of writs are as follows. Habeas corpus, certiorari, prohibition, mandamus and quo warranto. Now let's see each in details. Habeas corpus. Habeas corpus is a writ that is enforced in order to protect the fundamental right to liberty of an individual against unlawful detention. This writ commands a public official to deliver a detained person in front of the court and provide valid reasons for the detention. However, this writ cannot be issued in case the proceeding is for contempt of a legislature or a court. Certiorari. The writ of certiorari is issued to a lower court directing that the transfer of a case for review, usually with the intention of overruling the judgment of the lower court. The Supreme Court issues the writ of certiorari in case the decision passed by the lower court is challenged by the party. It is issued in case the higher court finds it a matter of overjurisdiction or lack of jurisdiction. It is one of the mechanisms by which the fundamental rights of the citizens are upheld. Prohibition. Prohibition is a writ issued by a higher court to a lower court to enforce inactivity in the jurisdiction. It happens only in case the higher court is of the discretion that the case falls outside the jurisdiction of the lower court. Writ of prohibition can only be issued against judicial and quasi-judicial authorities. Mandamus. The writ of mandamus is issued to a subordinate court, an officer of the government, or a corporation or other institution commanding the performance of certain acts or duties. Unlike habeas corpus, mandamus cannot be issued against a private individual. The writ of mandamus can be used to order the completion of a task, or in other cases, it may require an activity to be ceased. Quo warranto. Quo warranto is issued against a person who claims or usurps a public office. Through this writ, the court inquires by what authority the person supports his or her claim. Through this writ, The court inquires into the legality of a claim of a person to a public office. This writ prevents the illegal assumption of a public office by an individual. Now we will move on to the suspension of fundamental rights. Fundamental rights can be suspended in the case of national emergency as mentioned under Article 352. The 6 fundamental rights under Article 19 are automatically suspended in case under national emergency is imposed on grounds of war or external aggression, which is stated under Article 358. Article 359 has the clause for suspension of other rights. In that case, a separate notification has to be issued by the President. The rights mentioned under Article 20 and 21 can never be suspended. Constitutional emergency and financial emergency cannot affect the fundamental rights. If you find this video informative, do like, share, comment and subscribe to my channel. Thanks for watching my video. See you again.